I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity.
Well, a South Carolina justice had harsh words for the Colleton County clerk who may have influenced one of Alex Murdaugh's jurors. The judge stated that she believed the clerk answered the siren call of celebrity and may have put this guilty finding into question. Welcome to Profiling Evil, and thanks for hitting the like and subscribe button. Please share us with your friends, folks. Now, Alex Murdaugh enjoyed another day in the limelight as he sat in front of former South Carolina Supreme Court Justice Jean Toll in hopes of getting a new trial because the Colleton County clerk, a lady named Becky Hill, took the low road in her interactions with jurors during the widely viewed murder case. Now, you'll undoubtedly remember that Murdaugh was convicted of brutally murdering his wife, Maggie, and their son, Paul. It happened in their lowlands ranch. Brutal is an understatement when you consider the evidence that Murdaugh lured at least one of the two to the crime scene where he gunned them down. In fact, he gunned both of them down. After a lengthy trial, Murdaugh was found guilty, and as he sat in jail doing legal work in his own appeals, he put together this case with his lawyers. At least he's been doing it for the last 10 months. Now, 3 things came out loud and clear in the 2-day hearing, in my opinion. First, that Clerk Hill did, in fact, influence at least one of the jurors, according to that juror's testimony. Now, that all came to light after Justice Toll heard from all 12 jurors, plus the one alternate. She also heard from other witnesses and pored over the case information after hours. Tons of research on this case. Now, the second big moment, in my opinion, was when Judge Toll stated that Clerk Hill also, quote, stated her desire for a guilty verdict, close quote, because it would help sell books. How stupid is that? Now, Murdaugh and his lawyers couldn't have been more pleased at that point, and they may have even thought that they were out of the woods, so to speak, perhaps even heading for a retrial. Remember, this guy was found guilty after months, 6-week trial that resulted in his conviction on March 2nd, 2023. Now pay close attention to Murdaugh, who appears bored at times as he listens to Judge Toll hand down her ruling. Let's watch
The matter
this.
of the state of South Carolina against Richard Alexander Murdaugh. The following constitutes my ruling on this matter from the bench. This order will be supplemented, as I will explain, after proposed formal orders are received from each side in this matter. This case is unique in my 20 years of experience as a lawyer and my 35 years of experience as an active justice of the Supreme Court and a senior active trial and appellate judge. Usually matters involving possible improper contact with or conduct of a juror arise during or shortly after the trial. The judge then puts the affected juror or jurors under oath, conducts an examination, and rules on the request for a new trial or a mistrial. In this case, I was appointed almost 9 months after the trial to replace the trial judge who was recused. It is now almost 10 months after the verdict was rendered and sentence imposed in this matter. It is now on appeal to the Court of Appeals. Several months after the appeal was filed, the defendant moved that his appeal be suspended and this matter be remanded to the trial court to consider his motion for a new trial on a charge that the clerk of court for Colleton County tampered with the jury by expressing her opinion to the jurors about what their verdict should be and about the credibility of the defendant who had elected to take the stand and testify on his own behalf. Since this matter has been remanded to me, I have set the matter for a pretrial and a final hearing, conducted a telephonic status conference with the attorneys for the parties on December the 21st, 2023. I have received briefs from the parties. I conducted a pretrial proceeding on January the 16th, 2024, in which I invited briefs and arguments by the parties and by the attorneys for certain of the jurors and for the clerk of court, Rebecca Hill. On Friday, January the 26th, 2024, I conducted a hearing on this matter in which I took testimony from one of the jurors. The conduct of the examination conducted solely by me. I received further argument from the attorneys for the state and for the defendant. Today, January the 29th, 2024, I have taken sworn testimony from the remaining 11 jurors who rendered a verdict in this case. This examination was conducted solely by me. I have found no case that provides otherwise in the many cases I have read on the subject of a motion for a new trial on the basis of after-discovered evidence of jury tampering or misconduct. I have also received sworn testimony from the clerk of court, Rebecca Hill. Direct examination was conducted by Deputy Attorney General Creighton Waters. Cross-examination was conducted by Defendant Attorney Richard Harpootlian. I have also propounded questions myself to the clerk of court. I also received testimony from the clerk of court for Barnwell County, Rhonda McElveen, who attended most of the trial and assisted the clerk of court for Colleton County. I've also received testimony from the remaining alternate juror who was, when the matter was deliberated, dismissed from further service. The following is my ruling on the defendant's motion. The standard of proof. The state contends that in order to prevail, the defendant must show, 1, that the clerk of court made an improper comment or propounded an improper question to the member of the jury, to a member of the jury who rendered the verdict. 2, defendant must further show that Ms. Hill's improper comment or question actually influenced the juror's verdict, citing State v. Green, State v. Aldrett, and other opinions of our Supreme Court and other authorities. Defendant contends that he must show only that an improper question or comment was propounded to any juror by Clerk of Court Hill. If so proved, the defendant contends that the motion for the new trial must be granted. Defendant relies on United States v. Rimmer and many other cases. My ruling is this. On the law, the defendant has the burden of proving both the fact of the improper comment or question by the clerk of court, Rebecca Hill, to a juror or jurors, and 2, prejudice suffered by the defendant, specifically that the Hill improper comments to the juror or jurors influenced the juror to vote to convict defendant Murdaugh. The facts. Did Clerk of Court Hill make comments to any juror which expressed her opinion of what the verdict would be? Ms. Hill denies A, and so the question becomes, was her denial credible? I find that the clerk of court is not completely credible as a witness. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find that she stated to the clerk of court, Rhonda McElveen, and others, her desire for a guilty verdict because it would sell books. She made comments about Murdaugh's demeanor as he testified and she made some of those comments before he testified to at least one and maybe more jurors. Did Clerk of Court Hill's comments have any impact on the verdict of the jury? I find that the answer to this question is no. Each member of this jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied, and it is so ordered. I will file a fuller order which denies this motion on the grounds I have recited on the record before me as a trial judge and the authorities that have been cited by all parties in this matter. To that end, I will hold the record open. I direct that within 4 business days of receipt by the attorneys in this matter of a transcript of these proceedings, a proposed order by the state denying the defendant's motion for a new trial with citations be sent to me and to opposing counsel. I will allow the defendant 4 business days from receipt of the state's proposed order to lodge objections and or submit an alternative proposed order. Upon receipt by the court of all proposed orders, I will finalize this record, submit a written order, and I will at that time transmit the written order to the Court of Appeals, the court which has remanded this matter to me. This hearing is adjourned.
Well, this judge acknowledged Clerk Hill's fleeting and foolish comments, stating that the clerk was seeking publicity for her new book. I mean, how embarrassing for Hill, and frankly, rightly so. The judge went on to say that the Murdaugh team failed to meet the burden of proof of prejudice. That's number 3. There may have been improper conduct, but Murdaugh's team failed to prove what happened tainted the jury into voting guilty against him. And not to give up the spotlight too quickly, Judge Toll actually stopped everyone, and while she was still standing, asked the audience to sit for a few more moments while she reminded them of all her experience and the fact that she read the entire 6-week murder trial transcript and found the evidence that convicted Murdaugh to be overwhelming. And like a good judge should, she also called out the exemplary conduct of the state and the defense lawyers in the Murdaugh ongoing saga. Don't forget their names and faces, folks, because we're going to be hearing from them for years to come as the Murdaugh saga continues as he appeals his murder conviction.
Hey, members of the audience, would you just be patient with me for one more minute? Please keep your seats. I have probably had more experience with trial and appellate work than anyone else in this room for many years, and it has been an absolute pleasure to receive from these learned lawyers some of the best briefs I've ever received. I know they're a product not just of the attorneys who presented to me, but of the attorneys who sit with them and help compose the research and the writings that I received. I know that I put you on a very tight timeline, but my feeling is these matters are best disposed of by the trial judge in a very timely manner, so that you may then go to the authorities that really count more than I do. That is, the appellate authorities who will decide what the standard in this particular matter is. I've not seen a case such as this before. I doubt whether our appellate judges have seen a case such as this before. And they will take a lengthy time to study the record in this matter, the record in the part remanded to me. There are many issues in this case, issues over which I have absolutely no authority whatsoever. But I will say this about the record now that I have read it. And I will say this about the testimony that I heard Friday and today. Judge Newman said it best in his sentencing when he discussed the weight and the measure of the case presented and testimony and evidence submitted in this case when it was tried. It is a very compelling case supporting the verdict that the jurors reached. He said it with a lot more detail than I do, but now that I've read the record, I say as the successor trial judge, I agree that the evidence was overwhelming and the jury verdict not surprising. This matter is now adjourned.
What about Colleton County Clerk Becky Hill? Well, less than an hour after the ruling, Hill's attorneys, Justin Bamberg and a guy named Will Lewis, issued the following statement saying, quote, "We respect today's ruling by Justice Toll denying Alex Murdaugh's motion for a new trial. Justice Toll described Betty Hill's alleged comments at the center of Murdaugh's defense counsel's argument as fleeting, and that any interaction she had with jurors in no way influenced their collective decision on the facts of the case." They went on to say, "We agree with Justice Toll's findings that the Colleton County jurors selected for this very complicated and lengthy trial were consummate professionals who operated within the instructions of the court. We thank them for their service." Close quote. Well, not to be outdone, the South Carolina Attorney General, a guy named Alan Wilson, said, quote, "As with all cases, the Attorney General's office and SLED, our only mission is to seek the truth and deliver justice wherever the facts lead. It does not matter your name, position, status. No one is above the law. We take this very seriously, and in this situation, we immediately requested an investigation, regardless of what it might find. After that thorough investigation and a fair public hearing, it is clear that Alex Murdaugh's convictions for the murder of Maggie and Paul are based solely upon the facts and the evidence of the case. It's time to move on and forward." Close quote. Well, I've said it before, folks, and I'll say it again. The real information, the real facts lie in what isn't being said. It's not always in what verbally is communicated. The Alex Murdaugh case is long from being over, so buckle up. Hey, I'd like to know your thoughts on this one. Please weigh in below and let me know if you think Murdaugh will ultimately win the chance to have his murder conviction returned for another swipe at justice. I'm going to be reading your comments, and I hope you'll keep them appropriate. Now listen, you can find Profiling Evil on Facebook, Instagram, Twitter, and YouTube. And if you like podcasts, folks, that are audio, check out Profiling Evil podcasts on your favorite podcast platform. And do not forget about choir practice next Monday at 8 p.m. Mountain Time, first Monday of every month. I'm going to have on FBI profiler Mark Safrick and a street cop who's working the infamous Skid Row.
Hey everybody, look who I'm hanging out with. And listen, I'm not attending choir practice, but I just wanted to tell you that you need to be watching Profiling Evil YouTube. Don't miss it. I'm telling you, there's something there for you every single time. I never miss. You shouldn't either.
And I got Candace Cooley, Dylan Round's mom, coming on. So don't miss this chance to join the Profiling Evil community and have some great discussion. Hey folks, we'll see you soon at the next crime scene.